We are back to the second part of our program, Panel 4, Transnational and International Cooperation, Judicial Dialogue on Cooperation in Atrocity Cases at the regional and national levels. Our panelists, Judge Van Hyonsen, Judge International Residual Mechanism for Criminal Tribunals, Honorable Lady Justice Susan Oklani, Judge of the High Court, Republic of Uganda, Mr. Abubakar Tambadu, Registrar International Residual Mechanism for Criminal Tribunals, and Honorable Justice Dr. Fauz Twaib, President, East African Law Society. Our moderator, Mr. Matthew Carlson, Senior Legal Officer, Chambers, International Residual Mechanism for Criminal Tribunals. Mr. Matthew, the floor is yours.
Thank you, Saida. Before we begin, I'd like to thank President Gatti for organizing this colloquium. We're nearly done, and I would like to say that after nearly 22 years in this field and thinking about these issues, I've learned many things over the course of today and yesterday. In my view, this gathering is a true success and an important contribution to our continuing dialogue about how best to do justice in the aftermath of atrocity. The topic of this panel goes to the heart of accountability and its future, national prosecutions, and regional and state-to-state cooperation in this respect. I have supported international judges of the ICTR, ICTY, and mechanism since 2002, most of my professional career. I'm proud of the achievements of UN courts and think their role in accountability has driven the normalization of no more impunity. And they have authoritatively expanded on the rights of the accused, the elements of crimes, and the development of best practices. International courts have their place as courts of last resort, courts that adjudicate when a state is unwilling to prosecute or can't achieve the international cooperation to judge high-level perpetrators who have fled, as was the case with the highest echelons of the Rwandan government and military in 1994. But notwithstanding this experience and being part of this system, I continue to believe that in most cases, justice is done best locally by national and regional bodies, if possible. It must be close to the people concerned and affected. A key example is Rwanda and its Gacaca system, which tried tens and tens of thousands of accused in their communities. Accountability in Rwanda was seen through this process. In fact, most suspects of the Rwandan genocide against the Tutsi were prosecuted at home. The ICTR dealt with only a small fraction of perpetrators. It must be said, though, that these perpetrators, largely the highest level, were at the time beyond Rwanda's reach. In these cases, Chapter 7 of the UN Charter really helps. Rwanda, like Uganda, which we will hear about today, has established a specialized court to deal with international crimes. The ICTR has also referred several cases to this court for trial, including the 2 remaining fugitives. In addition to national courts focused on international crimes and domestic jurisdictions, the Malabo Protocol, which was recently elaborated, also provides and demands international cooperation and domestic prosecution. This is also on the table today. Earlier this month, another landmark treaty, the The Hague Convention on International Cooperation in the Investigation and Prosecution of International Crimes, was signed, further reflecting states' commitment to strengthen their cooperation in relation to the domestic investigation, prosecution, and extradition of persons suspected of atrocity crimes. Complementarity is the future, domestic trials are the future, and the legacy of the international tribunals that have come before must be leveraged as motivation at the local level to do justice in a way that is seen and understood. This is what we'll be talking about today. Let me introduce our distinguished panel of eminent and distinguished jurists and lawyers. First up will be the registrar of the mechanism, Mr. Abubakar Tambadu. Mr. Tambadou served as a distinguished prosecutor of the ICTR and mechanism, working on some of its most high-profile cases, and being the principal advisor to the first mechanism prosecutor. As Minister of Justice in the Gambia, he made history by bringing a landmark case before the ICJ against Myanmar in an effort to stop genocide. He is currently Registrar of our court, and his wealth of diverse experience at the national and international level ensures that his thoughts on the historical context of regional state cooperation, competing interests, and practical challenges will provide valuable insight. The Honorable Justice Dr. Fawz Twaib, a former distinguished Tanzanian judge, now legal practitioner, and president of the East African Law Society, will provide insight into the Malabo Accords and issues related to domestic prosecution in Tanzania. I am particularly interested in hearing his intervention and learning more about this important advancement in regional cooperation. We will also hear from the Honorable Lady Justice Okalani, whose extensive career as a prosecutor in Uganda and now as a judge on its court dealing with international crimes is unparalleled. She received Prosecutor of the Year in 2017 for her role in the 2010 Kampala bombings. She was also pretrial judge in a case that allowed the prosecution to bring charges of war crimes and crimes against humanity under customary international law, allowed victims to participate for the first time under national jurisdiction. She has also stood as a candidate for ICC prosecutor. She is on the cutting edge of justice for international crimes. I really look forward to her intervention. Finally, we will hear from Judge Jonson, a mechanism judge with extensive experience with the mechanism, the ICTR, including as its last president, in Kosovo as an UNMIC judge, and as a judge in Denmark. Judge Jonson will share his unique experience at the national, hybrid, and international levels. I already have several questions for the panel, but want to let them speak. And I also want to hear from you before I ask my own. So I will give the floor to each speaker and then turn it over to you to engage and continue this valuable conversation. Mr. Registrar, you have the floor.
Thank you very much, Matthew, for your kind introductions. Madam President, honorable judges, distinguished guests, it's no surprise that regional cooperation or state cooperation is on discussion by two panels. And that is because state cooperation lies at the heart of an international justice mechanism. Cooperation is where, I believe, international justice converges with international politics and international relations. In the case of regional cooperation, we cannot discuss state cooperation without situating this cooperation in the context of its historical and political evolution. If we take the major landmarks in the development of international law, the most significant milestones in the international lawmaking process, let's take perhaps 4 or 5. Let's start with the adoption of the UN Charter in 1945. And then, of course, the establishment of the International Law Commission by the General Assembly in 1947. The International Law Commission is the commission that has been mandated by the General Assembly to study and recommend the development of international law. Or we look at the Universal Declarations of Human Rights in 1948, or indeed the Genocide Convention in 1948. Or maybe perhaps the Geneva Conventions, the 4 Geneva Conventions in 1949. Now, all of these very, very significant milestones in international law occurred at a time when none of the states on the African continent, as it is today, had gained their independence. And what that means is that, in effect, none of the African states participated meaningfully in the international lawmaking process at that time. These were the foundations of the codification of international law. And so, the African states, unfortunately, did not start on an equal footing as perhaps states in other regions of the world. And so when the previous panel discussed and identified the practical challenges of cooperation, which range from political will or interest or lack thereof, from capacity, technical or human resources, I think what we must also ask is, why is that the case? Why is it that states in this region either lack the political will or interest, or lack the capacity, or lack the resources? Now, obviously, African states, states in the region, which did not participate in the international law making process, particularly in these 4 or 5 instruments that I have mentioned, didn't, in other words, have a sense of ownership of the process of international law, which naturally will mean less interest in it. Now, you need to stop me, Matt, if I am spending too much time in my introductory comments.
I'll stop you.
Okay, good. Because they did not participate in the negotiations leading to the adoption or establishment of all these very landmark international law developments, the sense of ownership was lacking. Now, fast forward 10 years after, say, the adoption of the Geneva Conventions in 1949, the first African state to gain independence was Ghana in 1957, which was then Gold Coast. And then between 1957 to 1962, a number of other African states also gained independence. Now, at the time of the struggle for independence, the focus of these African states that were struggling for independence was to take aspects of international law that served their objective of independence. And so what they did, naturally, as anyone would do, they cherry-picked. They decided to focus on the principles of international law that will aid their cause for independence. So they focus on, say, the right to self-determination in the UN Charter. And when they gained independence, in order to prevent or avoid interference by outsiders, especially the former colonial powers, they hung on to the notion of state sovereignty. Don't interfere in our affairs. We are a sovereign nation now, we are independent. What we do within our territorial borders is our business, not yours. And so the focus for these African states was on self-determination, independence, and the principle of sovereignty. And to be honest, these were the principles that favored them at that time. Nothing else mattered under international law for at least quite a lot of the states on the continent. Fast forward to the 90s, the early 90s, with the establishment of the ICTY and the ICTR by the Security Council under Chapter 7. It was an early warning sign to the African member states that the international law that you have ignored for so long is now coming around to haunt you. That international law is no longer going to be restricted to the consent of states. It's going to be intrusive, is going to be coercive, and that you must play by those rules, otherwise it will come to haunt. Now, that, I believe, was the beginning of a change in the attitude of quite a number of African states. They realized, on one hand, that they cannot continue relying on the doctrine of state sovereignty with the new development under international law, which is the creation of these new ad hoc tribunals under Chapter 7. And so they were caught in a dilemma. What do? We want to maintain our sovereignty. We want to tell outsiders not to interfere in our business. Yet, on the other hand, we want to be seen to be conforming to notions of international justice and humanity. The biggest number of arrests by the ICTR were conducted in Kenya and Cameroon, the two African nations that provided the most amount of cooperation in terms of arrest of fugitives of the Rwandan genocide. But at the same time, it woke them up. Fast forward again from the establishment of the two ad hoc tribunals to the establishment of the ICC, member states in the African region decided that if they do not participate in the process of building this new international court and participate in shaping the direction of this court, what had happened with the two ad hoc tribunals may also come back and haunt them. And so there was a mass movement within the African continent to not only participate in the negotiations for the establishment of the Rome Statute, but also the adoption of the Rome Statute. In fact, the Africa Group constituted the single biggest regional bloc in the ICC, under the ICC statute. Now, that's because they had realized that they needed to take ownership of these processes. And we all know that when people take ownership of processes, they are more likely to accept outcomes arising from those processes. It was good news for the continent. ICC membership, cooperation, and I believe if you cursorily go through a review of the statements of support in the early days of the ICC, at least in the first 5 years of the ICC, from members of the Africa Group, you will be in no doubt as to their preparedness to support and cooperate with the court. Over time, after or within the first 10 years, obviously there were some difficulties between the court and the Africa Group. This is still a matter of debate. While the majority of situations that the ICC was dealing with were referrals from the African continent, from the Africa Group countries, many on the continent felt, justifiably or unjustifiably, that the court was unfairly targeting African leaders. And so the difficult phase of cooperation between the court and the region started. But again, the African states, conscious of the need to continue to perpetuate the perception that they want to conform and uphold international law norms and values of justice and humanity, needed to find an answer to this difficult, challenging relationship with the court. And what was their answer? The Malabo Protocol. They created a protocol to extend the jurisdiction of the African Court of Human and People's Rights to include a criminal law jurisdiction. But again, it shows that even though the African continent didn't have a head start, it didn't have an equal opportunity to negotiate or participate in the negotiations for the establishment of very, very fundamental international law principles that were developed in the 40s, even before they became independent. And even though they hold on very strongly to the notion of sovereignty, which, by the way, was a sacrosanct principle for the Organization of African Unity, the predecessor to the African Union. But because of the evolution of international law over time, they had to find the balance between maintaining sovereignty on one hand and conforming to the universal values and norms of justice and humanity. And so it is that the Malabo Protocol was created. What is happening to the Malabo Protocol is perhaps something that we will discuss later, but I will stop here for now. Thank you, man.
Excellent. Thank you, Mr. Registrar. And you actually brought it right up to our next speaker. I thought it was particularly interesting in your discussion of sort of the evolution of the engagement of states in Africa that I picked up really tying it to the creation of the ad hocs that sort of spurred the interest in both engaging and building these institutions like the ICC and also sort of focusing domestically on doing that and taking ownership. So kind of, I'd never quite thought of that. That's kind of the particular moment. So that's very interesting. I'd now like to hear from Honorable Justice Dr. Twaib, in particular on the Malabo Accord and Tanzania. You have the floor.
Thank you very much, Matthew. As Registrar Honorable Tambadu just said, there has been an uneasiness amongst African countries vis-a-vis the ICC. And it is those sentiments that led the African bloc to come up with the Malabo Protocol. As he said, in the sense that this was something that came as an initiative from Africa within the African Union and would therefore bring stronger cooperation among African countries when it comes to atrocities and bring a sense of ownership amongst African countries. The protocol requires ratification of 15 members to become operative. Well, we haven't got that yet. As far as I know, there is no ratification. There are some countries that have already signed, but it has taken years now, and we don't have the operationalization of the protocol because sufficient ratifications are not there. The protocol significantly would create a new African court to take the place of the current African Court for People's and for Human and People's Rights, and also the African Court of Justice, and merge the two into an African court that would also have jurisdiction in trying international crimes. So it is for this reason that you find the significance of the protocol. Let me just proceed. The ratification would mean that you have a new court altogether. But there are certain shortcomings within the protocol, and they stem from the issues that Mr. Tambadu has mentioned. One of them significantly being the issue of sovereignty. It has amongst its provisions an exclusion of removing the jurisdiction of the court from prosecuting heads of states and heads of government. And it does not stop there, even senior officials of governments, which means really that the protocol has given with one hand and taken back with the other. That is one shortcoming. The other shortcoming is that state parties to the convention can make a reservation prohibiting or restricting access to the court to individuals and NGOs. Only organs of the AU and state parties can take matters to the court. And therefore, an individual who needs to access the court cannot do that directly. Or a non-governmental organization that wants to do that would not do that because the country against which you want to proceed has made a reservation, has declared that NGOs and individuals cannot access to the court vis-a-vis that particular country. So these are, I think, shortcomings within the protocol, which do not have a positive impact, or would not have a positive impact on its operation. I would want to come down now to East African and national, meaning Tanzanian situation. When it comes to cooperation for atrocities and international crimes, I don't know whether I'm heard. Do you hear me? Okay. You don't? Thank you. Yeah. One particular matter which was actually mentioned by my fellow panelists during the first session is that there is need for harmonization at these levels, the national levels. In Tanzania, for instance, we do not have a crime which may fit into these international crimes. We don't have a crime called genocide in our penal law. We don't have a crime of other human rights violations. And one would have to go to a crime such as murder, for instance, or grievous bodily harm. And therefore, prosecuting these crimes within the national jurisdictions may be legally difficult because the framework does not allow, the legal framework does not allow for the prosecution of these crimes. The other thing that may be a hindrance or a setback when it comes to national jurisdictions is the systems of proceeding against people when it comes to such crimes. For instance, in Tanzania, even though it may, for a person who is prosecuted for a particular crime, has a right to legal representation. But that legal representation is restricted in the sense that you would have to afford your own counsel, or in some serious cases, for instance, murder, the state would provide you with counsel. But your choice of counsel is very restricted because they would choose the counsel for you. And you do not have a choice as to who exactly should represent you unless you can pay for the services of counsel. There are matters such as, for instance, witness protection. In the international system, there are safeguards for that. But nationally, these are lacking. And you may find that when you need witness protection, the system of witness protection may not be available for you to ensure that the witnesses that are there are safe and that they will be available when it comes to giving testimonies in court. So these are issues I think that need to be addressed, and harmonization of these issues may require not only cooperation at the international level, but political will within the member states. And it is only with that that you can succeed in bringing down the international standards to the national level. I think that is for now. Thank you.
Thank you very much, Dr. Twaib. I thought it was a very interesting intervention, both about the positive developments of the Malabo Accord, but also its potential shortcomings. And I also very much appreciated hearing about the experience in Tanzania and the challenges there. I'd like to now hear from Honorable Lady Justice Okalani about your experience in Uganda.
Thank you so much, Matthew. I add my voice to the previous participants that have thanked the president of the mechanism for enabling me to be here. I have seen my colleague, Judge Richard Wawire. He must be here under the auspices of the East African Court of Justice, but it's still the same thing. He's benefiting, the ICD is benefiting twice. For Uganda, at a strategic level, we have been cooperating with the ICC. We referred the situation in northern Uganda to the ICC, and we have one successful case, the successful prosecution of Ongwen, Dominic. Yesterday, the decision on reparations was rendered by the court. However, at the direct level, our cooperation with the ICC has not been tangible. It may have just started, not started, but rebirthed recently, when the International Crimes Division of the High Court was established as a War Crimes Division, first of all by decree. There was collaboration with the ICC in regard to training. So many judges then had the opportunity to interact with the court, the ICC, and obtain some kind of training on the work of the ICC. And that led to the promulgation of our own rules, the ICD rules, which are sort of similar to the rules of procedure and evidence of the ICC. And then subsequently, we had domesticated the Rome Statute. And in domesticating the Rome Statute, the international, the War Crimes Division was converted to the War Crimes, the International Criminal Court, or International Crimes Court, where I happened to be one of the judges in that court. However, we had challenges, of course, since there was no direct collaboration with the ICC at the level of the court. The collaboration was strategic. It was not at our level. And so the judges that were trained by the ICC at the beginning retired, some were transferred, and we had a problem of posting judges that were about to retire to the ICD. You know, because it was believed by the judiciary that it didn't have a lot of workload, so it didn't need so many judges or young judges. And so they would post their judges who would be left with 3 months to complete the judgments that they had in other courts, to kind of get a little bit free time to do that in the ICD. And that worked badly for the court. Of course, when we started the hearing of Thomas Coelho, who is a kind of contemporary of Dominic Ongwen, we had a lot of challenges that most of those judges had retired or been transferred away. We had new rules to deal with. We had a lacuna in the law. I think that for any court that wants to, any country that wants to establish a court to try international crimes, the legal framework must be put in place. A clear, categorical legal framework that covers the relevant offenses for the period the charges have been brought. In our case, we had a lacuna in the law. We had the Rome Statute Act, passed in 2010. We had the Geneva Conventions, promulgated years ago, but we as a country had not ratified the convention aspects that deal with non-international conflict. And that was the kind of conflict of the LRA. So we couldn't bring charges under the Geneva Conventions either. Neither could we bring charges under the Rome Statute Act, lest we suffered the problem of legality of the charges. So the prosecution brought charges under customary international law. And there was an objection, of course, by the defense. And I had to render a decision that, given that even in international tribunals, the charges that are framed are based on international customary law, and the statutes that constitute those courts actually are passed ex post facto. Then the ICD could also try Thomas Coelho under international law. I felt like the charges that were brought under the penal code did not reflect the seriousness of the alleged crimes. So we go on to have the case tried. I confirmed the charges, but that was after a very long time. No support in courts from relevant international actors. The enthusiasm that we initially had and the excitement of establishing a court, of a complementarity court, had died down. The relevant actors had abandoned us. The defendant had sued us, a complaint to the African court, and the African Commission had rendered a decision granting him compensation for delayed trial, for the abuse of relevant provisions. I think provision Articles 3 and 7 of the African Charter. And that now caused us to be bashed. That's when the bashing came in, from the international community, from the victims, from civil society organizations, from human rights activists. And the bashing was now directed to the court, notwithstanding the fact that the judges that were now leading the court and new judges had nothing to do with the errors of the past. And so that is the kind of quagmire we had. However, since we took over the court officially, myself and the head of the station, things have turned around. And that is why I said we are rebirthing our collaboration with the ICC. We have also made a case to the powers that be in the judiciary, in the executive, to fund the court. Because of that, the prosecution has closed its case. I mean, we went into that trial. It's a panel hearing, 4 judges. That is very expensive. It's not common in our local jurisdiction. Although High Court judges can sit in panels, it rarely happens. So the expense of funding that panel to hear cases in the locus where the offenses happened was too much for the domestic court to handle without support. And the international partners that initially expressed interest in funding the court lost interest because they saw little action by the nation itself in implementing the reason why the court was established. So now we have a prima facie case established by the prosecution. The case is going on defense. We have done the latest outreach a few weeks ago to get witnesses for the defendant. We spoke with communities. The court was out there, myself and Judge Wawire. There's still goodwill and collaboration from the public, from the victims, from witnesses of all kinds. So when the defense starts in a few weeks, we expect that finally we shall have a decision before the middle of this year and redeem ourselves from the embarrassment. Thank you.
Very good. Thank you very much, Lady Justice Okolani. I thought it was particularly interesting to hear about the challenges and sort of the evolution and changes in your court over time. And I particularly appreciate your observations about when states or jurisdictions embark down the road to deal with atrocity crimes, there really needs to be a clear legal framework in place to actually make things go smoothly, which sort of dovetails with your earlier comment about harmonizing law to assist with state cooperation. So thank you very much for those. I'd like to now turn the floor over to Judge Jonsen, who has a wealth of experience both nationally, internationally, and also a quasi-domestic but internationalized court. I'm just wondering if you could share your insights, Judge.
Thank you, Matt. I've actually come on this panel through the back door. I was asked a few days ago to replace Judge Ben Kyoto from the African Court. And when I studied the program, I could see that he would address our subject here based on his experience as a judge of that court and his work in the African Commission. And I know I wouldn't get away with pretending to be able to represent these views. And I noted that on the panel, the mechanism was already represented by the registrar. So I discussed with Matt what on earth will I talk about. And we agreed I might have some supplementary comments to what has been said, or if not, I could go into my experience as a judge of UNMIK in Kosovo. I think the last issue is a bit far from what we have been discussing here. So I will, in connection to what has been said, sort of bring up how does this Malabo project leave the ICC? The ICC applies the complementarity principle, but in the Rome Statute, it actually says that the ICC does not have jurisdiction if a national jurisdiction takes over. But I know from discussions with ICC judges that it's the position of the ICC that the complementarity principle applies a fortiori to a regional court or a hybrid court. So it means that the cases that the Malabo court or a hybrid court can deal with doesn't need to go to or the ICC will not have the jurisdiction. And of course, a big part of the cases, African cases before the ICC has been the self-referrals from, among other countries, Uganda and Cote d'Ivoire, that is not even a state party. And of course, these cases can, without problems, go to Malabo Court. And as my colleagues here explained, the Malabo Court will not deal with political leaders. So that will still sort of be the center for the ICC's jurisdiction, I imagine. Another comment I have is to the issue of primacy and complementarity. It has been an issue in relations between the ICTR and Rwanda. Rwanda initially in 1994, when they were a member of the Security Council, actually brought up the idea of creating an ad hoc tribunal for Rwanda similar to the one that had been created the year before for the former Yugoslavia. But the outcome of the deliberations didn't please Rwanda, and they actually voted against the resolution. And one of the issues was the primacy issue. It didn't mean so much in relation to the genocide cases, because it was difficult for Rwanda to get extradition of the leaders who have fled Rwanda. It was much easier for the ICTR. But the prosecutor of the ICTR, in addition to prosecuting the most responsible, also wanted to prosecute on the mid-level, a sort of representative number of mid-level responsible, plus also prosecute sort of rogue elements of the Rwandan army, which had retaliated when they returned home and saw that their families had been massacred. But Rwanda would not agree to ICTR prosecuting the RPF troops, the rogue elements, not because they argued they shouldn't be prosecuted, but because they wanted to prosecute them themselves. And the Prosecutor General then, Marty Dengoga, claimed that the ICTR should actually learn from the recent development as exemplified by the Rome Statute and apply the complementarity principle. The issue was brought up before the Security Council, and at the same time, the Security Council was working on our completion strategy for the tribunals, and the outcome of it was that the tribunal was barred from issuing new indictments after a certain date. I think it was in 2004, and that actually closed the issue with respect to the Rwanda cases, because there was no time for issuing new indictments. The prosecutor had 4 cases which were under investigations. They were transferred to Rwanda and prosecuted by the Rwandan authorities. They were being monitored by the prosecution, and what I was told, it was satisfactory proceedings. These are sort of my complementary remarks. I don't see any angle into talking about Kosovo here. Thank you.
Thank you. I, of course, have questions after these interventions, but I thought maybe I would give the opportunity to the floor first to hear your questions and your voices as part of this exchange. So if there's any questions from the floor, I see Judge de Guzman, Judge Sekule, and Judge Lambert. So.
Thank you so much for the interesting interventions. I'm curious if the panelists could give us an update on the likelihood that the Malabo Protocol will come into effect. What are some of the considerations? What's stopping the ratifications from happening? And in addition, or perhaps relatedly, I'm wondering what the current thinking is about the immunity provision, which has been, of course, widely criticized from outside the continent, but is there pressure from within also to change that as part of seeking ratification? Thank you.
Dr. Twaib, do you want to respond, and perhaps also the registrar as well?
Thank you very much. Yes, the issue maybe that is holding back ratification could be those kinds of things. And the immunity provision really flies in the face of the principle of customary international law that gives immunity when it comes to prosecution in a third state, but it does not give that immunity for prosecutions in international criminal tribunals. But the immunity says, no, we will also have this, this protection when it comes to the African court, and that it can only deal with people other than senior officials of states. And I think that is the reason why it is taking so long to get ratifications. Whether there is pressure, it is very much a political issue, and in Africa, it is something that is quite common that politicians wouldn't want to face the law once they are out of office or even when they are in office. The idea here is that you may have an institution, but it will not be that effective because really these things are mostly done by politicians, and they can be done by politicians in power, and then you have nothing to do about it. So I would say the pressure might be there, but whether that would be sufficient to bring these countries to the point of ratification, that would be anybody's guess, in my view. Thank you.
Mr. Registrar, would you like to add anything?
Yes, just very briefly. I think it goes back to my earlier comment about the dilemma that African states face. I think what they gain at independence through the principles or international law principle of self-determination, they wanted to preserve through the doctrine of state sovereignty. And again, as I said, historically as a bulwark against outside interference, particularly the former colonial powers. That dilemma is reflected in the Malabo Protocol. It's still a conflict between sovereignty on one hand and adhering or be seen to be adhering to the principles and norms of international justice and humanity. And so long as that conflict is not resolved one way or the other, I don't envisage much progress on the Malabo Protocol. The Malabo Protocol was a knee-jerk reaction, if you like, to the increasing cases at the ICC targeting African leaders, or at least the perception. And I believe it wasn't well thought out because they still had to grapple or deal with the notion of state sovereignty. African states have not yet fully evolved from the point of state sovereignty, and that's understandable, as I said, because we had to play catch-up to the foundational principles establishing or rather codifying international law in many instances. And so with time, hopefully, there may be progress, but I don't see that happening in the immediate future. That's my view.
Thank you very much, Mr. Registrar. Unfortunately, Dr. Twaib had a plane to catch, so he stayed as long as he could. I greatly thank him for his participation. But I think we can move on to further questions. Chris, I think it was Judge Sukule, and then Judge Nyambe.
Well, it's a pity Dr. Twaib has left because I had a question getting to his presentation, but Registrar is here talking about the Malabo Protocol, so maybe I'll be able to proceed with my observation and question. Registrar, I have listened very carefully to observations at why, for example, African states in the earlier days did not react or respond to the various covenants that you have just mentioned. You mentioned at the beginning of your submissions. Reason given was that they did not own them, and of course, there's now the question of state sovereignty. That may be so, but if you look at the prevailing situation now, what is the position of areas, parts of the world that were party to these covenants and own them with regard to accountability of these atrocity crimes? How do you see it? What could be the problem? That's one. Two, you have given the reason why the Malabo Protocol may not easily, is not in operation, may not soon come into operation. Those reasons you have just stated. But I was also wondering, and that you can help me, Registrar, when you look at that document, was it not so massive? Because there is so much, so many things are put together. I know the idea could have been to create a court that might be seen, might replace perhaps the ICC notions. But there are so many aspects that have been included in that protocol. The way I've read it, could that also be a hindrance to perhaps to meaningful operation of this statute or of that protocol? So those are my two observations I wanted to make. Thank you very much for these are very important contribution. I think it has been nice to hear this presentation to all this particular panel. These are live issues. Thank you very much.
Thank you very much, Judge Sekule, for your questions. Very briefly, with respect to your first question about the position of the parties who were the original parties to the, or who own the process of developing these instruments that I had mentioned earlier. Well, I'm trying to be very diplomatic here now. Since I represent the Secretary General, there are certain things that I must avoid saying. But if you ask me plainly, if I take off my political hat as a representative of the UN and speak personally, I think we all recognize that there is an element of double standards in the positions that are taken across the world in conflicts and in situations where atrocity crimes are committed. And I believe that notwithstanding, what I can say for the African continent is that in spite of the challenges confronted early on, in spite of the fact that we needed to play catch-up, we have done tremendously well in terms of cooperation at the state level, particularly from state to state. I have several examples that I can provide, maybe one or two. We have seen how the African Union supported Senegal in the establishment of the extraordinary chambers in the courts of Senegal for the prosecution of Hissène Habré. We have seen the special court for Sierra Leone and the strides it has made to ensure accountability with the cooperation of many states, including the Gambia, where I come from. We are now talking about African Union supported tribunal for South Sudan that is also being discussed. We're talking about an ECOWAS-supported special tribunal for the Gambia. And I think African states are doing the best that they can. The fact that they still lag behind in terms of capacity, in terms of resources, in terms of interest at times, or political at times, as I said, is based purely on the historical and political context that I have provided earlier, but it's not for lack of ability. And I suppose in terms of resources, it's a question of prioritization. These are the competing interests that African states grapple with, but otherwise, I think I have said enough about the position of those who own the process right from the start. Now, in terms of the Malabo Protocol and the many issues that are included in there, I think personally, my own view is that the biggest hindrance, I think, all of those may also be hindrances, but they are not insurmountable. I think the biggest challenge of all is the challenge of sovereignty. And that is why the Malabo Protocol excluded heads of state, specifically from the category of persons who could be tried and punished, whereas customary international law, all the developments under the ICC statute, the ICTY, the ICTR, all of them didn't recognize the defense of official position. And so there is a variance there, and again, it goes back to the struggle for independence. That's the concept that we must never lose sight of. What they gain in independence through self-determination, they want to preserve through state sovereignty. And until we move away from that, we're going to have difficulties in implementing the Malabo Protocol. Thank you.
Thank you, Mr. Registrar. I think a lot of challenges have been noted in relation to the protocol's potential gaps, but I think your overall response in terms of cooperation does leave me feeling more hopeful on balance that things are moving in the right direction. I think Judge Nyembe had the next question.
Thank you for recognizing my hand. And mine is not a question. Mine is to supplement the registrar's submission on cooperation with the ICTR first. Just to complete your record, my personal involvement and practical experience is that there was tremendous support for the Rwanda Tribunal from the very beginning. And this cooperation extended to the host country because we had to have negotiation where the tribunal was going to be based. It goes to the Rwandan government because without the Rwandan government providing witnesses, you would not have had the courts functioning. For example, going back to the beginning, when the very first accused persons were transferred to the tribunal, it was at that level that the state-to-state cooperation really played its role. When there were 3 of them, the very first accused to come to here, arrested in Zambia, there was no prison here yet for the for Rwanda Tribunal. There was no court. So we had to come scampering to the Tanzanian government to make the facilities available. The first, we had to have prison facilities to bring them in. But all these governments put aside their own shortcomings by making provisions for these accused persons to come here. So I just want to compliment your submission about the cooperation. I remember as a senior legal officer driving all the way to Mwanza to get Judge Sekule's signature to sign the first indictment, and then traveling to Durban, to South Africa. We had incredible cooperation also in the beginning. So the countries in the region were absolutely incredible. The 8 accused from Kenya, you saw the result, but you did not see the background negotiation and cooperation and bending forwards and backwards to make sure that the Rwanda tribunal functioned. I just wanted to supplement your submission. Thank you.
Thank you very much, Judge Nyambe. Are there any other questions? Judge Bosa?
Thank you. I'd like to extend my gratitude to all the presenters for their illuminating presentations. My question goes to Judge Okalani. Judge, you said that you have adopted the rules of the ICD and they are modeled on the ICC rules. I'm just wondering that since the background, and I'm not sure here, to the prosecution of Hoya law is the same as that of Dominic Ongwen, or maybe similar, are you considering admitting adjudicated facts from, say, Ongwen or some other cases? Do the rules allow that? Thank you.
Justice Bosa, Justice O'Connor.
Thank you so much, my lady, for your question. The answer is no, because the rules that we have are not as comprehensive as the ICC rules. And there are so many gaps. And then we, under our legal regime, also apply domestic laws, including the Trial on Indictments Act, the Evidence Act, and so on and so forth. And these rules, our laws, our domestic laws, limit certain aspects of the rules of procedure for the court that you sit in. So that is the big gap that we have. We've asked the principal judge to harmonize our rules depending on the problems that we are coming across. Although under our own Evidence Act, I think it is not, it needs a wild judge to make that decision, because evidence that is admitted in other courts can actually be used as evidence. But so far, from what I know about the case, there has been no such need on the side of the prosecution. They've closed their case without requiring that evidence.
Thank you very much. Actually, before we go to the next question, Judge Jonsen wanted to make some observations based on Judge Nyambe's observations. So we're effectively answering a question before, and then we'll go to the next one.
Well, people who know me and Judge Nyambe also know that we seldom agree. But on this occasion, I agree with Judge Nyambe. We had some issues with the tracking of Kabuga some years ago, and the proceedings concerning Kayishima is dragging out, but at least he was arrested at our request. But otherwise, in my opinion, we can be very satisfied with the cooperation we have received from African states, especially compared to some European states where it has dragged out, especially with France, where we had to refer 3 cases because it seems impossible to persuade France to extradite them to us. And I know the ICTY has had problems also in relation to certain countries in the former Yugoslavia and tracking of Milosevic and others. So you are right, Africa is playing a very positive role in our proceedings.
Very good, thank you, Judge Jonsen. I believe there's a question right there. just in front of Amanda.
Thank you. My name is Esther. I work for Pan-African Lawyers Union. We litigate a lot at the African Court and the East African Court of Justice. And I wanted to weigh in on two things. One on the Malabo Protocol, and it's more to buttress what the Honorable Registrar said. I think if we were to be very, very honest with ourselves, this is all about the lack of political will. And why I say this, already the court that we have, the African Court, how many of the 55 states currently allow individuals and NGOs to bring cases before the court? 8 out of the 4 that have ratified the protocol, and out of the 55 countries that are members of the AU. So do we honestly believe that these same states want now to have an organ that holds them even more responsible for their acts? If even just the African Court itself, as currently it is, they do not want to allow their citizens to go before it. And what we have seen consistently, whenever there's a judgment that the states don't like, what do? They withdraw. They ensure that they withdraw Article 34.6, and that means then their citizens cannot file directly. As it is now, I think it's only Pan-African Lawyers Organization and one more organization that can file an advisory opinion before the African Court. Where does that leave us? Do we truly believe that states want the Malabo Protocol to see the light of day? So it's a conversation that can be had at a different time. The other thing that the Honorable Registrar said that I found interesting was the issue of cooperation. I think states only want to cooperate when there's something of interest to them. You spoke about the South Sudan tribunal that is supposed to be established. How many years since the idea was born has it existed? And do we honestly feel the AU has pushed enough to establish this? I did my thesis a bit on this when I was doing my master's last year. And it was just sad when you listen to the people and how much they feel the AU has failed them in ensuring that they've actually been heard on what has happened to them in South Sudan. So I think it comes down to political will, and then we have to have the bigger conversation for how long will we keep talking about the same questions and what are we doing to change the situation?
Thank you very much for those questions and observations. Mr. Registrar?
Just very quickly, I wanted to blow my own trumpet that the Gambia was one of the 8 countries that had signed the declaration for direct individual petitions, and that was during my time as Attorney General there. So the credit goes to me. You better applaud me. But on the South Sudan case and the African Union, I think we must be honest. I agree with you about the frustrations, but we must also be realistic that states tend to make decisions based on narrow state interests without exception. And so the African Union is a very complex beast. As I'm sure you know, since the days of the Organization of African Unity to where it has. But we must also recognize that tremendous progress has been made by the African Union. It doesn't mean it's still perfect. It doesn't mean that we are getting everything that we want. But I believe that they have contributed, particularly individual states, and the examples are too many to illustrate here. It's a question of consensus at the African Union. That is a big hindrance to progress. They want to agree on everything as a united front, and that more often than not creates obstacles for meaningful progress at the level of the African Union. So that is a challenge, and unless and until that approach is changed, we will continue to be frustrated by the slow pace of events because they believe in Africanization. They believe in dialogue, they believe in consensus. You can't have consensus for 55 states all the time. It's almost impossible. And that's one of the key obstacles to progress of the African Union. But we must also recognize the progress that individual members of the African Union have made in terms of cooperating with mechanisms that deal with mass atrocity crimes.
Thank you, Mr. Registrar. Are there other questions from the floor? Very good. We have about 10 minutes left. I have a few of my own. Lady Justice Okalani, we often talk at these conferences about sometimes international tribunals establishing best practices, maybe leading the way, inspiring domestic activity. But I'd like to sort of flip the question, and from your experience, what can other jurisdictions learn from your court?
Thank you so much. I used to say that I am the officer in charge of what not to do when you are establishing an international tribunal or a tribunal to try international crimes. And I have already said the lesson, which is that it should go beyond the initial excitement. My brother here has said states have narrow interests. And that is what, I don't know what the narrow interests were at the time of establishing of the international. Of course, it came from the collaboration with the then semi-autonomous South Sudan, the Juba Peace Accord. So that must have been, the intention was to end the war. How do we end this war peacefully, you know? So everything was done in that hurry. Let's start a court, let's start a transitional justice mechanism, but which did not take off immediately. So I think in the reverse way, what other countries can learn is that, first of all, you should have a robust legal framework that I've already mentioned, and then you should do a deep assessment of possible challenges in prosecution of these crimes, based on what others have already experienced, what the tribunals, the UN tribunals have seen. So you don't go there when you are, it should be sober, that it should go beyond the law. Establishing laws per se is just the beginning. It's not everything. So we've been very proud as a country, we ratified the statute. We are the first to have this kind of court, blah, 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 blah. But the legal and institutional frameworks is the beginning of it all. There's a need for analyzing the impediments, how to circumvent the tough terrain in specific contexts of each case, how to yield more input from international actors. It is important to anticipate, of course, hard times, look at the logistics. But yes, on the positive side, here we are. We circumvented the law, so to say, the problem of a lack of a robust framework. And we went to the international customary international law, and the trial has gone on. It is ending, it's soon ending, so we shall have that aspect of a concluded trial. Also, we have been cooperating at a strategic level with the court, the ICC, and we can also take a little bit of credit for the decision in when we have had collaboration in respect of dealing with victims. The ICC has supported victims in terms of obtaining psychosocial support, all of them, psychosocial support. There are still some victims who have not received treatment. They have bullets lodged in their bodies. That is also a problem, that we did not pass the transitional justice mechanism to deal with cases like Rwanda did with the Gachacha. There are so many of those cases which do not come to the level of the court, the ICD or the ICC, but they still needed to be handled. Recently, I went for an outreach, and most victims just wanted to be allowed to exhume their loved ones. That is their idea of reparations. We might be thinking of money, we are thinking of many other things, but for them, a decent burial, a recognition by the government of Uganda that these relatives of theirs died, a memorial somewhere is what they and of course we have the transitional justice mechanism that we are now implementing. It is important that even while we have accountability, the aspect of reconciliation should be also looked at immediately so that other victims get their redress immediately and they don't have to wait for the cases of Ongwen or Thomas Koyelo. We are still working, we're building on our collaboration with academia, regional organizations, and so on and so forth. And again, the ICC has come to us and requested 2 weeks ago that the pre-trial of Joseph Kony in absentia be conducted in Kampala. And we said, yes, why not? And so we are still collaborating in that regard. Maybe if he comes home, as there's a rumor that he wants to surrender, he might be tried in Uganda, and that will benefit both the ICC and us, the domestic jurisdiction. Thank you.
Thank you very much. We have a few minutes left. I have one question each for our other two panelists. Judge Johnson, you've judged at several levels, international, sort of a mixed system, and in Denmark. At which level would you say were there the most challenges in terms of cooperation, and why?
Well, there weren't many challenges in Denmark. I mean, we're 6 million people and know everything about everybody. So it's a comparison between the Kosovo court and here. And the Kosovo court was special in the sense that it was an existing law system. There were no special statute or special rules of evidence and so on applicable to our proceedings. We joined the court, and most of us didn't have any experience with civil law. It was sort of an Austrian-Hungarian version, and it created a lot of challenges. Judges had to ask the questions during the evidentiary proceedings, during the trial. Of course, you can do that, and so, but it also meant that the prosecutor had to shut up. And that was a problem, especially for our American prosecutors, who were sort of very flamboyant. And with respect to sort of cooperation, Kosovo was under UN administration, so the police was UN police. The military was also under UN command, so it was sort of a small dictatorship where people cooperated or else. So it wasn't really a problem. Of course, here it's much more complex because we have no problem with cooperation from Tanzania, but that's logistical issues, and we have received excellent treatment here, second to none. But when we need cooperation from other African states, it's sort of more tricky and can also differ from place to place depending on the capacity and the local rules. So I would say this is the most challenging place I've been. Thank you.
Thank you, Judge Johnson. And for the final question to the registrar, I'm interested to know very quickly, because people might be getting hungry, how has Gambia's engagement with the ICJ and also your rich experience coming from the ICTR mechanism, the former prosecutors coming back and being domestic officials as Attorney General, et cetera, how has that impacted the legal culture in Gambia at the national level, domestic courts, domestic prosecutions?
It had a tremendous impact, I believe, and I can give a lot of examples on how. And one of them is, as you mentioned, the ICJ case. It was as a result of the experience gained from the ICTR and prosecuting a terrible genocide in Rwanda, which basically inspired the Gambia's case at the ICJ. But more importantly, in terms of domestic level capacity. When I went as a Minister of Justice, there was an international law division of the Attorney General's chambers, but only in name. There was no single lawyer who was working in that division. And so with some effort, obviously, I managed to rebuild this international law office with some lawyers, provided them with training, both in the Gambia and abroad. And I believe the results are now obvious. I believe George Hofer, who is here in Germany, will testify to the fact that the Gambian government the Gambian state was able to fully support and cooperate with the German authorities in a recent trial of a Gambian who was a member of an assassination team which the former president ran in the country, and he was apprehended in Germany. He was prosecuted successfully and sentenced a few months ago, and I believe Judge Hofer, who is here, if she is willing, can provide more. But that's one example of the effect of the effort that was made in the Gambia as a result of the experience that I carry with me. And just to say that we currently also have 2 other ongoing processes in the US and in Switzerland, which again the Gambian state is helping and cooperating with as a result of the creation and reinforcement of this international law department of the Justice Ministry at the time I was there. Thank you.
Thank you very much, Mr. Registrar. I'd like to thank you all for this excellent panel. To my panelists, you're really at the forefront of international criminal justice. It's been a pleasure engaging with you. I'd also like to thank the audience for your interventions, which have really added to today's discussions. Before we close, could you just please join me in thanking our panel members?